Good afternoon, everyone. My name is Matt Brakey. I am president of Brakey Energy. Brakey Energy provides comprehensive energy management services to large users of energy. And we serve our clients' facilities located in the state of Ohio. Carolyn Brakey is my wife, which is why this will be a fun trivia factoid for the next conference. This is probably the only workshop that is being given with two people physically next to each other, as opposed to in their own little computer windows in various parts of the state and country. Carolyn is both general counsel to Brakey Energy. She handles Brakey Energy's legal issues, but also wears quite a few different hats in addition to that. She has also recently launched her own law firm, Brakey Law, of which she is the principal of. And you want to give a 10-second description of Brakey Law to put you on the spot?
No. But I will. Brakey Law serves large users of energy and helps them with energy law issues, both regulatory transactions and litigation.
And Carolyn is parlaying. I always use this word to describe this recent venture of hers. She is parlaying some recent legal successes of her prior law practice at a firm where she originated a class action lawsuit against First Energy Solutions, which we'll discuss later in this presentation, but that's settled for $12 million. And what should be very exciting is that customers are in the process of getting checks for that lawsuit right now. So if you are a customer, if you are a supplier that serves customers that at one time were served by First Energy Solutions, it's very possible that some quite noteworthy checks are coming their way. And then the other recent legal success Carolyn had is she originated a class action lawsuit against Cleveland Public Power, which just had a very major appellate victory. So no final outcome for customers in that case yet, but very exciting things. So my role in this presentation, other than just having given these introductions, is I'm going to basically go through some very high level, what is electric generation and how does that fit within an electric bill, just to make sure everyone knows where we're at by the time we get to the more nuanced conversation that Carolyn is going to have about the legal issues surrounding electric generation. I'm also self-appointing myself as being in charge of handling our dog Megawatt, Meg for short. If she starts barking, I'm very hopeful, because the mailman just came and just rang the doorbell. So yeah. I'm hopeful that is out of her system, but just in case, I am armed and ready, and I will do my duties in that respect as well. So let's get right into it. And if you have any questions, you can use the chat function for the time being. I think Carolyn is monitoring that, or at least intends to monitor that. And we also hope to give people the option to unmute themselves, not too far into the presentation. There's not an inordinate amount of people attending this workshop, so I think it shouldn't be a problem to give people the opportunity to jump in and ask any questions. So with that being said, so quick introduction to electric generation. Okay, so the billing components of an electric bill: you have distribution, transmission, and generation. Distribution being the poles and wires and substations and transformers. Transmission, the high voltage lines that it's essentially the highway of electrons that move electricity across long distances. And then you have electric generation, which is the generation of the electron itself. And then the main subcomponents of electric generation, at least within PJM, and I know there's been some discussion of what's going on in Texas and in the very unfortunate crisis they seem to find themselves in right now with widespread outages. Now, I don't profess to be an ERCOT expert, but I do know that they have no capacity market within ERCOT, and that is different than PJM. So the main subcomponents of electric generation within the PJM Regional Transmission Organization, you have energy, which is just the electron itself. You have ancillary services, which are services associated with reliability, which actually gave rise to the legal issue that Carolyn will discuss with her class action lawsuit that recently settled with First Energy Solutions, and also what I think is causing some pretty jaw-dropping price outcomes in the Texas market right now. And then you have capacity, which is just a generator's ability to generate or a user's ability to curtail during grid peak times. And really, with the capacity, I probably should update this slide because with the capacity performance changes to the PJM capacity market, the availability is really just now ongoing year round. So when contracting for electric generation on a retail level, there are 3 core electric generation products. There are some others that, in my opinion, tend to get a little too cute, and we stay away from them. But on one extreme would be a fixed contract where a customer pays a fixed price for energy regardless of how much power it consumes, absent limiting contractual provisions, which Carolyn will speak to. Block and index, which has been a favorite of mine, particularly for customers that have that are load responsive and perhaps willing to wear a bit more risk. With this type of product, customer pays a fixed price for energy for a kW block of power that is hedged on the forward market, and then every kW consumed above or below the block is reconciled in the hourly spot market, either the day ahead or the real time, depending on what the contract calls for. And then index would be just the price paid for energy is tied wholly to the hourly spot market. I'll tell you, if you've been on this product the last 12 years, it has served you very, very well, but boy, it can be a bit of a roller coaster. That's not to say we don't have clients on a 100% index contract. We do. We tend to put, it tends to be for very unique situations, like lots of our foundry clients that exclusively melt off peak. We just keep them 100% index because they don't wear the same type of risk that, let's say, a weather sensitive customer that operates on peak may have to fluctuations in spot market prices. But it is not a contract for all users, let's put it that way. So we talked a little bit about capacity, but capacity is the amount of electricity available at the grid at any one time. It's a generator's ability to produce or user's ability to curtail, as I previously mentioned. So electricity must be produced and consumed simultaneously. Sufficient capacity during peak demand periods is necessary, or quite frankly, the lights go out. And again, Texas is basically right now is presenting the slide for us, I think, because it goes to show the theory behind the need for a capacity market to make sure that there's sufficient electric generation resources available in the most extreme of conditions. So capacity costs in the PJM wholesale market are determined by a series of auctions. The base residual auction, or BRA, is the primary driver of any delivery year's capacity clearing price. And as we've heard in previous workshops, capacity auctions have been delayed, so we're in a very peculiar situation where we only know the capacity BRA price for the next delivery year, that being June 2021 through May 2022. Normally, we would know the next two what delivery years after that would already be, but because of delays, we don't know that. But there should be a catch-up period in the coming 2 years where hopefully a lot of that will resolve itself. So peak load contribution, or PLC. So I've talked about the base residual auction and clearing prices for capacity. A PLC is a shopping customer that's competitively sourcing power. Their peak load contribution determines its allocation of capacity costs. Conceptually, I think of it as a capacity speeding ticket. So a PLC is determined by a customer's average usage during 5 coincident peaks, or CPs. And a CP is one of the 5 hours out of the year where demand on the electric grid, specifically the PJM electric grid, is at its highest. So basically, you look to see how a customer consumes power during one of these coincident peaks. You take the average of 5 of them, you put them into a formula, including the base residual auction clearing price, and it can spit out a customer's capacity auction for a given delivery year. So breaking energy, when we're evaluating supplier offers, we like to consider the price, the product, the contract terms, the counterparty risk, and also customer service. And I'll tell you, counterparty risk, that it will be very interesting to see what plays out in the Texas market, because there is going to be a lot of companies that, if they did not hedge properly, are going to have some pretty horrific and outsized exposure to some of these outlier events in the ERCOT market. And so it would not surprise me that you're going to see a lot of companies go out of business, and so their contracts may not actually be worth the paper that they're written on. And then many of Carolyn's counterparties in Texas, I suspect the litigation will flow from these events. So we'll stay tuned for that. All right, Carolyn, I believe it's to you. Contract considerations.
Did you want to talk about customer service, that bullet?
Do I want to talk about customer service? Sure. I guess I will say that it is every supplier screws up, and you know, Jennifer, who I know is on this, hopefully she's nodding her head right now in her house, because she deals with the billing issues. Every supplier is going to mess up bills. It's just a question. Nod.
We got a
All
nod,
right, thank you, Jennifer. Okay, that's a nod, yes, right? Okay. Every supplier is going to be making billing mistakes. It just happens. You just want to make sure that when these errors happen, they are addressed in a prompt and customer-friendly kind of way. And so if you go into the assumption that these mistakes are going to happen, it really separates the wheat from the chaff to see how suppliers handle these things. And so for me, it can easily be dispositive if offers are very similar in every aspect, but I know, supplier A has bent over backwards to do right for our customers in the past, and then supplier B perhaps hasn't. So did that sufficiently address the?
Yeah, absolutely.
Okay.
I just wanted to make sure all the bullets were covered.
Okay.
So,
counselor.
Yeah. So I'm going to talk about some contract basics first before we go into important contractual provisions in your next electric generation agreement. So I know there's at least a few attorneys on listening in, but for those of you who are not an attorney, I thought I would just talk about what a contract is. So a contract is just a voluntary agreement between two parties. It's the result of a negotiation between the parties, or bargaining. and it's going to set forth the rights and the obligation of each. So I always like to think about if in a contract, or even, we talk about, our rights all the time, right? Our right to free speech. Well, if somebody has a right to something, another party has an obligation. So if you have a right to free speech, that means another party has an obligation to provide you that ground for free speech. If you have a right to health care, that means someone else has to provide you that health care. So there's
that's Hofeldian analysis, right?
Is it?
Yes.
I was thinking it was Lockean. I didn't know.
It's
but,
Wesley Hofeld.
Okay.
I went to law school. I am not an attorney, as my wife likes to remind me, but I do throw in annoying little trinkets from time to time like this.
So, I mean, not to get into this philosophical debate, I guess, but this also, extends to contracts as well. So when it comes to an electric generation contract, the most important obligation of the supplier is supplying electricity. And then that means the most important right of the customer is receiving that electricity. And the most important obligation of the customer is providing payment. And then the most important right of the supplier would be receiving the payment. But then there's also obviously a lot of other provisions that go into an agreement, which I'm going to get into in just a minute. So there are three components to most generation agreements. You could kind of say 2.5, and I'll tell you why in a minute. So first is the master agreement. This is an umbrella agreement that would apply to all sorts of products, all sorts of customers, and it's going to set forth the majority of the terms and the conditions of the party. Second of that is the sales confirmation, or which sometimes is called the transaction confirmation. I think there are other terms as well, depending on the supplier. And that agreement is going to be more customer specific. It's going to talk about what the product is, and it may even modify the master agreement. So generally what happens if a customer is going to renew an agreement, they're just going to execute a new sales confirmation. And so, law may have changed, for example, so the sales confirmation may say, replace paragraph 32 with the following. So that sort of thing will happen in a sales confirmation as well. And then finally, you have the pricing attachment, which is obviously the pricing. It may also have historical usage in it as well, account numbers, that sort of thing. And it's actually an attachment generally to the sales confirmation, which is why I say there is like 2.5 components to the agreement. So one thing to think about is, and this is true for any contract really, is who bears the risk. So to the extent that the supplier is bearing more risk, then the customer's price is generally going to increase. And then the reverse is true as well. So there's obviously a bit of a risk reward thing for a customer and for a supplier as well, as far as how much risk they're willing to bear for what price.
And that's one reason I mentioned in my earlier comments the different types of customers we tend to have on that different spectrum of contracts, ranging from all and fixed to index. So index is certainly the way to go, all else being equal, if you're willing to wear that risk. And it makes sense, I think, for customers that just by the nature of their load type, if they are able to wear that risk because, let's say, they exclusively operate off peak, or perhaps have tremendous load responsiveness, it makes sense for the customer to shoulder that. Other folks, for various reasons, it doesn't make sense, and they should end up on the opposite side of that spectrum.
Okay. So, Matt had that slide about things that, breaking energy we consider before putting a customer in an agreement. And there are, he listed, I think, 5 or 6 things, and they're all very important. But I think maybe the most important for most folks is just the price. And so as far as that goes, when reviewing a contract, I always try to look at what's included in the price, what's being passed through, and how can those that price change. So there's, I'll go into a few provisions that will apply that could implicate a price change. Another thing to think about with the price is what is the broker's commission if you're using a broker. So at Breaking Energy, we don't do any embedded commission with our products. We are compensated in a different model. But generally, if a customer is working with a broker, that commission is going to be both discretionary and incremental. And by that, I mean the broker decides how large or how small that commission is. And it's incremental, as in it's on every kilowatt hour consumed. It's generally a fraction of a mil, or so many mils on usage. So that will never, at least I've never seen it transparently shown in a contract, but it can be very significant, and a broker has an obligation to provide that information if the customer asks it. Okay, so swing or bandwidth provision. This is one of those provisions that can change what a customer pays. Agreement with some sort of fixed component wouldn't apply to an index product. So a swing or a bandwidth provision is going to detail how a customer, if they alter their usage, what the penalty will be. So there's going to be usage history included in the agreement, and the swing is going to be a certain percentage of that usage. It's generally somewhere in the realms of 10% to 100%. 100% would mean you could double your usage or go down to zero without penalty. And when I say penalty, the penalty is typically either monetary damages or a change in the price going forward. Some agreements will also have an additional clause that requires the customer to notify the supplier if there is a material change in usage. So that example I had of, if a customer goes down to zero, but they have 100% swing, they have no damages in that case, except if there is a material deviation provision, which may be an additional step in which they just have to notify the supplier that their usage is being decreased significantly. So as far as from a customer perspective, really the best swing, the best bandwidth is just the smallest one that you're comfortable with your operations, because when I talked in the beginning about more risk equals a lower price. So to the extent that you have a lower swing, and by lower I mean 10%, 20%, something like that, generally your price is going to also be lower.
And I think 2020 is perhaps no better example for the type of time period where swing provisions can potentially be enforced, because you really had two things. Not only did you have significant change in how customers were using power as a result of the lockdowns, et cetera, but you also ended up seeing a huge delta between the forward prices that most customers were hedging at when they entered into agreements and what the spot market ultimately cleared at. So from a supplier perspective, you had suppliers who were projecting a certain amount of load to be online during this period of time. They put in a hedge at this price for this load, and then load fell off a cliff, prices fell off a cliff, and that resulted in a lot of suppliers taking some pretty significant losses.
Yeah, and I think to that too, to the extent a customer's usage for 2020 went down because they were forced to close or voluntarily closed, if that is used for historically looking forward for a swing provision, that could be detrimental to a customer. So, if your usage was 10% of what it normally was in March and April, you would not want that usage to be used for, projections going forward.
Yeah, and I'll tell you, the longer I'm in this business, the more humility I think I tend to have of predicting what customers may use. Which I don't think anyone could have foreseen, but I remember one client many, many years ago, their consumption fell off a cliff significantly for a few months, and it was the result of the tsunami in Japan. Essentially, they weren't able to get parts from Japan, and so they weren't able to do any production. So it's very easy for unforeseen things to cause changes in customers' consumption.
All right, moving on, a PLC change provision. I always say this is my least favorite contract provision in a generation contract. So PLC change provision, a unilateral one anyway, it's going to allow the supplier to upwardly adjust the contract price the customer's capacity obligation increases. And if the capacity obligation decreased, the price is still the same. So it's really like a worst case scenario for the customer. Heads, suppliers wins, tails, customer loses. And what I really dislike about these provisions is I feel like suppliers can be kind of sneaky about them. If you control F an agreement for PLC change, you're probably going to come up with nothing. They're often buried in the change of law provision. They may be, one supplier was burying it in like miscellaneous section. So they're kind of hard to find, and they have huge implications for customers. So I really dislike these. And for us at Breaky Energy, Breaky Law, it's an absolute deal breaker. We are not going to put a customer in this ever.
Yeah, and there's an easy solution, which is just you contract, instead of doing an all-in fixed contract, which includes capacity, just do a capacity pass-through contract. And so there are lots of very good suppliers that have these types of provisions. And quite frankly, I suppose if Breaky Energy was a supplier, we would want this type of provision to protect us in case a customer saw a dramatic change in PLC. So I understand why suppliers want them. Again, lots of good and reputable suppliers have them. But from a customer perspective, you're a lot better off just passing capacity through on a variable basis rather than entering into an all-in fixed contract where the supplier could unilaterally change the price on you if the facts just happen to change against their interests.
And there is also something called a bilateral PLC change provision, and this would allow the customer to reap the benefit if their PLC decreases. And you say, well, why would you do that rather than just passing through capacity? But this would allow you to amortize capacity costs and then still be able to PLC manage.
Yeah, we saw that particularly in the ATSU zone in 2015 and 16 when you saw that huge spike in capacity clearing prices. There were some customers that wanted to amortize that out over a period of years. And so some clients did enter into contracts with bilateral PLC change provisions to allow them to smooth that out, but still get the positive benefit of any sort of PLC change in the customer's interest.
Okay, so a change in law provision, similar to the last few provisions I talked about, and that this is a provision that can cause the customer's price to change. In this case, the price can change if there is a change in law or regulation. So this may seem like something like for a customer, like, oh my gosh, it's terrible. Why would you want this? But it's actually perfectly reasonable because a generation contract, I mean, it's probably going to be a minimum of 1 year, maybe 2 or 3 years. And over that time, I mean, of course, we're having this whole conference in part just because energy policy, energy regulations, they're like constantly changing. And so for a supplier to, predict the future 3 years or, so out is completely unreasonable. And so to the extent there wasn't a change in law provision, I mean, the price would just have to be so high if it was a fixed price for it to be worth the supplier's time.
Yeah, to properly account for that risk, a supplier would probably have to quote you a price you wouldn't want to contract for. So so these types of provisions are totally reasonable in our estimation. It just becomes a question of how broad.
Yeah, so that's what I was gonna say next is just I like to have it, fairly narrowly tailored. I like to see a notice requirement. Obviously any sort of capitalized term in a contract is something that's defined with a special definition. And so you'd want to see what all those terms are. But one I've noticed in particular suppliers like to do is law will be like capital. Am I doing the law? I think I actually do it this. I'm not sure which mirror version that you see of me though. But anyway, I've often seen that like law is capitalized and law could have this really like long open-ended, definition. It could be a change and, all these different things or similar. And that sort of thing can lead to a lot of unpredictability for a customer. So I don't like to see that. I always try to negotiate also what more of like a bilateral change in law as well. So in case that there's a change in law that actually decreases the supplier's cost, the customer should also be able to reap that benefit. And that's one of those things that sounds purely academic, but it actually has happened in the past. I mean, the transmission cost used to be on the supplier side of the bill and then went to the utility, and then now in some cases they're back on the supplier side. But there are times that the supplier's cost could actually decrease, and you would want that advantage on your bill as well. And I would say though, in practicality, I've never seen a supplier, take advantage of a customer in that way, but that is something that I personally like to see in an agreement. And this one's yours.
Oh, this is my slide.
Yeah, you got
this is my one slide. This is my island in Carolyn's sea of slides. So I talked before about delayed capacity auctions. One thing I have noticed and sniffing around with some other brokers have been doing for customers and hearing some complaints from suppliers, and maybe I got Jennifer to nod earlier to a question. Maybe I can get some suppliers to give a nod to this issue. Is that we're seeing a lot of brokers, and I'm not going to speculate as to why they're doing this. You know what, I will. I think some of them are perhaps lack the sophistication and understanding as to why this approach could very well prove to be very problematic for their customers. But they are continuing to exclusively solicit all-in fixed price products despite the base residual auctions having been delayed, and that we don't know what base residual auction capacity clearing prices will be starting in June 2022. So if you solicit an all-in fixed product that includes capacity for a period of time beyond that, some assumptions have to be made as to what the capacity clearing prices will be. Now, I have seen some suppliers who are wearing that risk and are saying, hey, I will give you an all-in fixed price that includes capacity. I'm, going to take my best guess as to what the capacity clearing prices are going to be. This tends to be suppliers that own generation, so they kind of see this as a way of hedging some of their portfolio risk, and they will contract customers to include a capacity price past the most recent BRA. You have other suppliers that are quoting an all-in fixed price where essentially they're putting in some sort of placeholder estimate for what a capacity auction will clear at. And to the extent that the capacity auctions in the future actually clear at a higher price, the contract allows them to upwardly adjust the price of that all-in fixed agreement, which creates a perverse incentive for suppliers to essentially estimate a very low, perhaps unreasonably low, clearing price for future BRAs, build that into the all-in fixed price that they are quoting. And then these brokers, when they're soliciting, they say, well, this supplier is the lowest price, even though they don't necessarily understand or appreciate or care that this customer's contract is going to be upwardly adjusted once these BRAs are held and the prices are announced. And the supplier that at first look like the most competitive actually is going to be anything but. I did not touch a single one of these bullets. I just ad-libbed, but
I feel
let's
like
go.
you covered them.
Yeah.
Okay. Holdover and evergreen provision. So a holdover provision is going to automatically renew the agreement or keep it evergreen unless either party takes action. Like, what are you doing?
Just doing that
yeah.
punchline there.
Yeah, I mean, we're doing electric generation agreement punchline, so they're not going to be good guys. I'm really sorry.
I liked it.
So when I initially started, reviewing these agreements, I thought this sounded like a great idea, these evergreen provisions, because, occasionally you have a client that kind of drags their feet about getting into a new agreement for whatever reason. Maybe there's, a management issue, or we work with some government organizations that they have to do these complicated RFP processes and get approved by the board. And so, I was like, oh, well, we don't want to get into a situation where the client is not in an agreement and they get knocked to the SSO. But what we kept seeing in practicality is a lot of times the price in these holdover provisions is terrible for the customers. It's higher than the SSO, so the customer would be much better just getting kicked to the SSO.
And I'm not sure if have we defined SSO? I think maybe we have, but it's standard service offer, which is the price customers otherwise pay if they're not competitively sourcing power. Sorry.
Yeah, so it would just be, the utility standard price is would be a much better situation for customers. So I don't think that a holdover provision is necessarily terrible. If it's narrowly tailored, you'd really want to be specific about the price. Just calling it a market-based price is really not enough. I like to see the supplier's adder actually defined, like a not to exceed price of, whatever mills that would be.
And you know what? I'll even go a step farther to say I'm not going to mention the supplier by name, because I actually think they're a really good supplier, with the exception of this. But there are suppliers that it is built into their business model essentially to ream customers with this type of provision. They have razor thin margins, serving customers when they solicit and quote fixed price contracts. And their calculus is a percent of our customers aren't going to get it together, and they are going to not contract, and we're just going to be able to gouge them on the back end. And that's where we're going to make our money, not just on that customer, but all those other customers that didn't. I mean, these provisions can be extraordinarily expensive. And also, I mean, this is also true on the residential side. So for anyone that gets our newsletter, we've started highlighting residential offers. And there's like this incredible 6-month offer right now. I won't mention the supplier name, but you can find it on our newsletter, that they're offering 3.6 cents all in for residential, which is just an incredible price. But what their entire plan is after the 6-month period, they're hoping you don't contract with someone else so they can gouge you. And so, we try, at least so far, we've stayed on top of it. I would hope we can do it. But maybe we should let it slip for a month, just as a
to see how bad the price is.
Yeah.
And then that's
next class action lawsuit. There we go, guys.
I was going to say our next presentation.
Yeah. No. Okay. We're gonna have to delete this because we don't want this showing up in court.
I know, right?
Filing, but.
Yeah, we didn't even have a disclaimer in the beginning, like most people do, about like these are only our own opinions.
Yeah.
But one time I really do like to have an evergreen is we have some clients that are in the NMB pilot program in First Energy, and I like to make sure they are on an evergreen provision, because if they are not, and you probably can talk about this a little better than I can, but if they default to the standard service offer, then they would get kicked out of the program. Is that correct?
Yes.
They have to be with a supplier. So for those customers, I mean, an evergreen provision is actually pretty essential. Oh, and then the other thing I was going to say about, and I knew I was forgetting something. The other thing I was going to say about an evergreen provision that can just get a little hairy is sometimes it can actually hold up the customer contracting, getting a new contract because of the notice requirements. So sometimes they're even, 60, 90 days, they have to provide notice to the supplier before they can get out of that holdover. And that can prohibit the customer from getting it at a more friendly price. Okay, an assignment provision. This allows the supplier or the customer to assign the contract to another party. Generally, the language for these is, more not bilateral. It's much more friendly to the customer, or to the supplier rather, than the customer. So I just try to get these as close as I can. At a minimum, I like to see that the new supplier, if the supplier assigns the contract, the new supplier has similar financial standing. If the customer doesn't get to reject or deny, or accept or deny the new contract, but I'd rather the customer has at least some discretion on whether they accept the contract, and it can even be, if it says it won't be unreasonably withheld. But generally what you're going to want to avoid as a customer in this situation is, picking this great supplier, great customer service, all those things Matt mentioned that we look for, and you contract with that kind of supplier, and then that supplier assigns your contract to like Billy Bob and Company with like no assets in the ground. That's definitely, a kind of worst case scenario. So that's just the sort of language and situation I try to avoid.
Yeah, and also Carolyn brought up the transmission pilot for First Energy Territory, the NMB pilot. So that can also be one important consideration. If a supplier that is accommodating this NMB pilot, let's say their book is acquired by another supplier that does not accommodate the NMB pilot, that potentially could be a catastrophic outcome for the customer, and essentially be headed for contractual breach if people aren't paying attention to what's going on. So,
right.
All the more reasons why we tend to give assignment provisions particular care.
Yeah, and I would also say that, a lot of times we negotiate special provisions for clients, including an NMB pilot provision, or sometimes if a client has on-site generation, we want to make sure the supplier is aware of that on-site generation. So any sort of provisions like that are special to the customer's agreement and compared to the standard agreement is something you'd want to make sure the new supplier is aware of and is able to accommodate. So I just outlined here sort of when your contract will really like kick into high gear sort of situations. One would be is when the customer would own the facility and the electric usage would drop to zero. This would be a situation, sometimes we have a client that may move and then the facility is just open, nobody else is in it. And so if they have 100% swing in that facility, there'd be no damages in that situation as long as the meter is still kept in place. And then another situation we see a lot is the customer selling a facility to another company. And this is when the assignment language may kick in. And then finally, the supplier selling his book of business. I mean, that's kind of what we just discussed just now. And like I said, so these provisions for unique situations, this is really important with if there's a new supplier that is assigned the agreement. And I just included some miscellaneous provisions that we look at. Choice of law, choice of venue. A lot of times you have suppliers out of Texas and they want to do choice of law, choice of venue in Texas, and that's like a no. This is electricity energy is so state specific that you definitely want Ohio to be your choice of law. And unless you have operations, somewhere else in the country, you probably want any sort of trial to be in Ohio. And I also see a lot, generally jury trial waivers, class action waivers are included in standard contracts. I always try to get those out too. I mean, those are obviously supplier.
Especially the class action waivers.
Yeah.
Right, Carolyn?
Yeah. Okay, so what can go wrong? I mean, a lot, guys. A lot can go wrong. Supplier passing through debatable charges. So I'll talk about that more in a minute. But obviously this happens quite a bit. And what I would look at, is what I outlined in the slide here. Does the contract allow the supplier to pass through the charge? Is the charge without markup? Is in like some sort of adder for the supplier. So, if there's a change in law, it should be, at least the contract should be written that the supplier is not allowed to make an additional margin on that. And then finally, is there a notice requirement that the supplier give proper notice? So early termination by either party. The contract would include how the damages were inside. And I think I really went through all of these already as examples. So finally, I'm going to do a quick case study. This is on the polar vortex surcharge by First Energy Solutions.
And to the conference tech team, if can go ahead and allow people to be to unmute themselves if they so desire at this point. So if there are any questions that come up, since we're starting to approach the end of the presentation, they can ask them, or of course, people are free to ask questions in the chat if they so desire. Yeah,
feel free to interrupt us. We will not be caught off a game or offended or anything. Yeah, Matt would be. I'm fine with it. So you may recall the polar vortex event in 2014. If you're in the Cleveland area right now, like we are.
Not the one of now.
I was going to say it's like right now in Cleveland, it is very, very cold. I'm not sure how it is in the rest of the state and where everyone else is, if that's a nationwide event, but we were in the negative numbers this morning. And so it certainly reminded me of the 2014 polar vortex. And during that time, all the generation suppliers in PJM incurred increased costs in order for PJM to ensure a reliable electricity supply on the grid during that time. So while all of the suppliers had those increased costs, only one supplier, at least one major supplier that I'm aware of, passed those through to customers, which was First Energy Solutions. They passed those through only to their business customers, their commercial and industrial customers. Residential customers, they threatened to initially and got a lot of flack, so they ended up not, and unfortunately they still passed it through to the commercial industrial folks. So they were in, those folks were all in fixed rate contracts, and particularly all fixed ancillary services charges, which is what these PJM costs would fall under. So the charge was billed to customers as the RTO expense surcharge, and it amounted to 1% of the customer's annual electric generation expenditure. So that wasn't a huge charge for a customer that spends, say, $1 million a year. That would be, what, $10,000. So not a huge expense, but something. It was enough to make folks unhappy. So kind of applying some of the things I talked about before, this was the change of law provision in FES's contract at the time. Some folks had some things a little bit different than this, but this is the provision that most folks had. So it says if any regional transmission organization, in that case would be PJM, requires a change. Okay, so if any RTO imposes upon supplier new or additional charges or requirements relating to the electricity supply under this agreement, then customer agrees that FES can essentially pass through those charges. So it's talking about a new or additional charge that PJM would impose on supplier that would increase their cost. So I guess I'll go to the next slide. So this resulted in a lot of litigation.
Because the issue was not, the charges weren't new or additional.
Yeah, well, I was going to get to that, but
stealing
okay.
your thunder.
Yeah, it's all right. It's all right. It's all right.
charges weren't new or additional. They were just high.
Right.
There were no like
Yeah,
new.
so I'll go back to that slide.
Okay.
Okay. Yes. So FES's argument were that the PGM charges were new or additional charges, and customers and myself argued that no, these weren't new or additional charges, guys. These were just high charges. That's a difference than new or additional. If I went to the gas pump today and gas was $10 a gallon, I wouldn't say, oh man, look at these new or additional charges for gas. I would say, dang, this gas is high, right? This price for gas is high. And so PGM wasn't providing any additional services. They were providing the same services as always. It just happened to be more expensive during the polar vortex. So there were two DJs that were filed in Cuyahoga. One was Lincoln Electric et al. That included, I think it was around 10 large commercial industrial users, Marathon Petroleum, Progressive Insurance, Lincoln Electric, obviously, and some other folks were included in that one. And I represented the plaintiffs in that case. And then about a year later, Schwegelach on its own filed a separate DJ. Both of those cases were dismissed with prejudice in the end, which it basically means the parties settled out of court and they're unable to refile. There were also a lot of PUCO complaints. One of the largest ones was Power for Schools. All of those were eventually dismissed. Some of them because the PUCO stated, I believe they lacked jurisdiction to determine contract disputes, but many of them were just also settled out of court, dismissed with prejudice. Finally, there was a class action, and I represented the lead plaintiff, Schwabel Banking Company, as well as the class in that action. And that ended up, we ended up becoming creditors in the First Energy Solutions bankruptcy case, which is why it's shown as it is, and that settled for $12 million. If you think you may be a class member, if you were an FES business customer and you paid the RTO surcharge, you may be a class member. And well, I should say that in that those DJ actions, those folks did not pay the surcharge, which is why they were filed the way they were. So class members also included just folks that paid the surcharge and didn't obviously independently settle with the FES. So they started receiving settlement checks at the end of 2020, and I listed the website there if you may be interested in seeing more about it.
Can I ask you a question? Who was the expert witness on that?
Matt Brakey,
okay.
President of Brakey Energy.
Okay, that's right.
Was the expert witness in the class action.
Okay, sounds like he did a great job.
He really knocked it out of the park, guys.
Thank you. But in all seriousness, with that case, as I think we mentioned earlier, those checks are starting to go out now, and some of them are actually quite sizable. So to the extent you're a customer and you think you paid that surcharge, and First Energy Solutions certainly had a very large share of the market during this period of time. So there's a lot of customers that were affected by this. And you did not independently reach settlement with First Energy Solutions on this charge through a different proceeding. You very well may be entitled to this settlement payment. The claims administrator has sent out forms basically saying, hey, if you're getting more than $600, and there's lots of companies that are getting thousands, if not tens of thousands of dollars in this settlement, you need to return your W-9 to the claims administrator. To the extent you're not unsure if that applies to you, reach out to Carolyn and she will work with the claims administrator on your behalf to find that off. Now, for you suppliers out there, you know that we're trying to help your customers any way you can. There's lots of them that might be entitled to payment and just aren't aware of it because they ignored this little postcard in the mail. So if you have any customers that you think are entitled to payment in this class action, again, you can reach out to Carolyn, or you can also just go directly to that website and reach the claims administrator through that portal. Yeah,
absolutely. All right, guys.
So any any questions, either written or anyone brave enough to unmute themselves and ask?
Hi, this is Anthony. First of all, great presentation. I really appreciate you walking through everything. So my question is, given the current COVID landscape that we're all living in, what would you say is the most important contract provision to be looking at when, say, signing fixed price contracts?
Do you want to take that, or?
No, you go ahead first.
I would probably say bandwidth or swing. As far as specifically, because most customers, there's very few customers whose load profiles haven't been materially altered one way or another. I mean, we see customers where their consumption has actually, like, we've got a client that makes parts for a ventilator, and their business really like took off. And then we also work with like the Cleveland Cavaliers, and they haven't been able to hold events until recently. So I would say bandwidth.
Yeah.
Swing.
Yeah, and particularly compared to historical usage, I think I'd be interested in, what was inserted for that historical usage. Is that based on 2020 numbers, or maybe looking back a little further?
Yeah.
But I'd be very cautious about those sort of.
And that would be an important consideration. Contracts, maybe not something you're even looking at doing right now, but something you might be looking to do it in like a year from now. If they're looking back and saying, okay, this is how you were using power in 2020, and that's no longer representative of your world anymore, you may want to adjust the usage that they're using for purposes of determining a swing tolerance.
Mm-hmm. That's a good question. Thank you.
Thank you.
Thank you.
Thank you, Renee. We can be a good team. On parenting, it can be a little shaky.
I was going to say, our kids may have different opinions than our teamwork. But.
Yeah, thank you. All right. Any other questions before we break?
Yeah, feel free to reach out to us individually.
Yeah, including anyone who may have watched this on a recorded basis. Feel free to reach out to us independently. Happy to help with any questions.
I had one question. Could you explain a little bit more about the counterparty risk that you mentioned on slide 8 and how you would evaluate that?
Sure. You want me to take this?
Yeah, that was your slide. That was one of your 3 slides.
Okay.
So you can go for it.
Yeah, it's funny this question comes up, because sometimes I do think I like gloss over this concept more than perhaps I should. So ultimately, and I think we're going to see this in Texas. Ultimately, any sort of a contract, let's get philosophical again, a contract at its foundation is just a series of promises. And you are reliant on your counterparty to honor their promise. And so, in my mind, some parties are more likely to honor those promises than others, particularly those that may have a better higher credit score, for example, perhaps have been in the industry longer. I'll mention a company by name, since they have now gone out of business, but there's a company called Kona.
Oh gosh.
That was offering prices that were just so ridiculously low, and it was because they were from Texas, and they just never bothered to learn how the capacity market worked in PJM, and they just completely were underpricing capacity. Mm-hmm. And it was, in my mind, a foregone conclusion that they were going to go bankrupt, that they weren't going to be able to honor their promises. So it's not that we didn't contract clients with them as a supplier. It's just we told them, listen, you're just going to ride them like a Bronco, and eventually they're going to throw you off when they go bankrupt, which is what ended up happening. So that's one extreme. And then there's other extremes, and I don't want to play favorites with suppliers, but there are some suppliers with like very, very high credit ratings.
Mhm.
And when you see what's happened in Texas, when you see what happened this, in 2020, as a result of the lockdowns and so much load disappearing and spot prices collapsing, and people not being able to pay their electric bills, the default risk among suppliers right now, I think, is extraordinarily high. And I think it's Warren Buffett who says, when the tide goes out, you see who's swimming naked. And I think, the tide's going out right now. And so we're going to see some suppliers that are going to be defaulting. So that's why I just think you need to be very sensitive to which supplier you contract with, because they may not be there to honor the promise if, certain things go awry, and that certainly has been the case in the last 12 months.
Excellent. Thank you.
Thank you. Well, thanks again, everyone. Really appreciate. Sorry we couldn't do this in person, but I look forward to seeing everyone next year in Columbus, physically at the conference. And I think they may actually be doing a hybrid virtual model next year, which would be, I think, a great idea. I think this conference has actually worked out about as well as it possibly could have under the circumstances. And I think it's, I think the conference will be better off for it in future years. So thanks again, everyone, for joining. And don't hesitate to reach out, and we'll see you all next year. Thank you.
Thanks, guys.
Bye-bye.